Get ready for another episode of Registry Matters, brought to you by our amazing lifetime patrons, Justin, Brian, and Michael. And remember, don't forget to embrace the odd, the unexpected. Yes, you've got it right. FYP.
Recording live from FYP Studios East and West, transmitting across the internet. This is episode 355. Oh man, look, Larry, in 2 episodes, we get to be like a 357 Magnum. Bang, bang, bang. This is 355 of Registry Matters. How are you tonight?
Doing awesome. Ready to get this show on the road.
On the road, eh? Anything exciting going on in Larryville?
Not anything particular out of the ordinary, but remember, I have a boring life.
All you do is read Foreign Affairs and The Economist so that you can go talk to legislators.
And I don't even do that anymore because it requires too much energy.
Oh, man. All right. Well, please make sure you like and subscribe. And we had a lot of chatter over on Reddit this week, so thank you. Somebody new who had never heard of us. I post a link over there to it, and he was like, watch this. I'm not clicking on any links. So if that is you, thank you and welcome. And then like, subscribe, YouTube. You said we had some new YouTube subscribers, so that's awesome. And if you would like to be very generous, as the people that are listening to us live this evening have done, they have become patrons, and you can do that over at patreon.com/registry matters, and it is so very much appreciated. What are we doing tonight?
Well, I'm having to break more bad news again. Chance is unable to join us today, but he does plan to be back next week. He had, his wife had to travel internationally, and people tell me that when your wife comes back, you're supposed to meet them at the airport. Are you familiar with that concept by any chance?
I mean, if you had a significant other that you were trying to keep in your good graces, or you in their good graces, I think you should probably go.
Well, that's what he's trying to tell me, but I told him, tell her to get an Uber.
just have, screw that. When she lands at the airport, have her hit the button on the Uber, and it will be waiting for her.
That's
Screw
right.
that. That's too much work to do that for her. She should do it.
But this means it's just Mr. Doom and Gloom again for this episode. But we're going to have a discussion about Sean P. Diddy Combs, and you're going to tell everybody who he is and what it's all about. And also there's a segment by Andy, yours truly, not yours truly, but you truly.
You're Andy now?
We have a question about registration in the state of Colorado that's been floating on the National Association of Criminal Defense Lawyers listserv, and I thought it was fun to dig into it. And if time permits, we plan to circle back on IML and answer the question that keeps coming up: why didn't President Obama, why didn't he just veto it?
It's garbage legislation. It seems like an easy win right there. Just strike the thing out with the pen, however they do it. Do they have a stamp that says veto? How do they do it?
I'm not sure. I've never actually seen the vetoed copy, but I suspect it has a stamp on it, and it probably has a line where the governor or the president says vetoed. And I know they send a veto message to the governor sends a veto message of explaining why it was vetoed.
Well, very well. Let us do this little NACDL thing. That's the National Association of Criminal Defense Lawyers. And you get emails from them? Is that what I understand that you're doing here?
It is what happens.
All right. And so you have a question posted on this NACDL, which sounds like pterodactyl, NACDL listserv. I will read it, and it says, I have a client who has been charged with indecent exposure under Broomfield Municipal Code, and he has been offered a deferred sentence. If he accepts this offer and pleads guilty, will he have to register? I'm not clear on whether it being a municipal code violation or it being a deferred sentence would keep him from having to register. What are your thoughts? First of all, Broomfield, is that where is that?
It's a suburb of Denver.
Okay. Oh, I guess that's why you brought up Colorado. Gotcha. All right. Continue, please.
It's in Boulder County, if I remember right. Well, the registration statute, I took a quick gander at it, and so did the people on the listserv. It's Colorado Revised Statutes 16-22-103, and it does not specifically address municipal ordinance violations. And I have not located any case law that addresses this question. And if I were licensed to give this advice, I would say it would not trigger a duty to register. But assuming an ordinance violation could trigger duty to register, the differences between the ordinance and the indecent exposure statute, the indecent exposure is a state statute, would be important. The state statute requires specific intent to arouse or satisfy the sexual desire of any person, unless the exposure is accompanied by, we can't say that on a family program, but self-gratification. And by contrast, the Broomfield Ordinance doesn't require any sexual intent. It reads, it's unlawful for any person to intentionally expose his or her privates to the view of any person under circumstances which such conduct is likely to cause affront or alarm to another person or persons. And that's Broomfield Municipal Code 9-16-030. The short answer, it's too darn complicated and nobody knows for sure. If I had the client, I would say you don't have to register, because the way I read Colorado law, it says that it has to be a state law. It doesn't mention municipal, and they do have that on the thread here that it doesn't mention. But it has to be a state statute or an equivalent for another state or jurisdiction. And they defined jurisdictions earlier, and jurisdiction is not defined as being a municipality. It's defined as being a state or a territory. So therefore, I would say he doesn't have to register at all. But that could get risky if you take that position and don't take their beautiful plea agreement, because if they're saying you have to register at least for the period of deferred sentence and you say no, then the question will be, could they charge you under state statute, dismiss the Broomfield Ordinance and refile it, get the state district attorney, Boulder County District Attorney, to file it. And that would be funny if they had the requisite proof that the indecent exposure was for the intent to arouse the sexual desires of any person, and then the person had to register as a PFR for a much longer period of time. So there's risk to this, but nobody knows the answer to it, including the lawyers on the listserv, and they're paid a whole bunch of money.
Now, just help me in my little pea brain over here, that I saw when I was getting locked up that if you had X amount of dope, they could move things up and charge you federally. And I'm only making the distinction between state charges and federal. This sounds like much more local, like your little county or your little city versus state. But is this similar to that they could just leave it at a municipal thing, or they could throw it up to the state level, which would obviously come with all those extra consequences?
Sort of, yes, sort of, but not completely. The feds usually have rigid criteria of what cases they will take because they want to keep their 100% success rate. And they don't like to take cases that are confusing and iffy. But in this instance, what happens with the municipal ordinances is that the penalty is much less, and oftentimes the municipal violations do not trigger the right to a jury trial. So a person is facing, say, 90 days upon conviction in the county or in the local lockup. Well, you're not entitled to a jury trial in most jurisdictions unless you're facing 6 months or a year or whatever. So they charge you municipally, and it's a favor to you because the penalties are much less, and you're not likely to get jail time because guess what? Broomfield does not want to pay Boulder to house their inmates, and I doubt they have a local jail that they would keep someone in Broomfield. I don't know that for sure. But they don't want to pay Boulder $142 a day to keep this person for 3 months in the jail. So they're not going to send him to jail.
I gotcha.
So,
and so this is that gamble that he could try to posture and go, ha 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 ha, this doesn't really apply to me. And then they could say, well, no, it's state charges, so have a nice day. And then that takes you into court under that whole regime.
I would be inclined not to posture. I would be inclined to take the plea, and then if they tell me to register, it's too late at that point because the plea's already been accepted and the sentence is in execution. So I would say, I appreciate that, but as I reviewed the law very carefully and talked to legal professionals, Broomfield is not a jurisdiction as described, so therefore I don't have to register, and not even for the period
Right.
of the deferment. So that would be a bait and switch, and they would think you were funny. And if they could get you, if they could get you on something else later, they would.
Yeah, I gotcha. Interesting. Okay. And will you do anything proactive in contacting this individual?
No, because I don't know any more than the people that are pontificating. We're all guessing. Nobody knows what.
Is this why lawyers are always practicing, Larry?
That is why they're always practicing. And I did less research than what some of these lawyers that are based in Colorado did. So our AI guru in Colorado may tell me that I've got it wrong, but I think I did enough that this is correct.
And he is not here this evening. All right, well then we shall head over to the main event, which of course was all over the news this week. And so this is about P. Diddy and what is it? Sean Puffy Combs is the guy's name. And what?
I'm not sure. I never heard this guy until he got in trouble, but go ahead.
Yes, I believe his name is Sean, and I don't even know is his actual middle name Puffy, but he has I don't follow him at all. Obviously he's been around for forever and wildly successful. Anywho, but so you want to discuss some articles about this, and the first one says that a do-over attempt falls short as the judge declines to toss convictions. Now, I hear this all the time where it is reported that someone filed a motion for a new trial after a unanimous jury verdict. Now, does this particular motion ever succeed?
It succeeds very rarely, but it's perfunctory. You're going to file that motion after you've lost the trial. You're going to set the record that you've tried everything before you do the full-blown appeal. And also it generates a little bit more billable time. If you're on a billable hour case, you say, well, look, let's file a motion to toss the verdict. And then if we ask for a new trial, if that's granted, then we don't have to do the appeal. And of course, the unsophisticated client says, oh, well, yes, let's see if we can get a new trial. They don't bother to tell you 99.99875% of those motions for a new trial are denied.
You use the word perfunctory? What is this word?
I don't know. Look it up. It means just kind of like auto, it's going to be done as a matter of routine. It's not really taken seriously. The attorneys do that as I hate to say they're crooked, but I would tell you, look, we can file a motion to throw out the trial results. But in my years of doing this, I've not seen those motions granted. So I'm going to have to charge you to do it. And the state's going to respond in opposition, and it's likely to be denied. But if you want to do it, we can do that. But be aware, it's not likely to work. And of course, then they run down to the next law office that tells them the good things that they want to hear, and they say that he's a big a-hole and he's so negative, and don't have anything to do with him. That's what they do.
All right. Well, the article says that Sean Diddy Combs failed to sway a federal judge to scrap his criminal convictions on Tuesday in a lead up to his sentencing. He argued that he was producing porn, not facilitating prostitution as he was convicted of, by paying male escorts to participate in quote-unquote freak-offs with his girlfriends. Now, how did that go?
Well, now, I'd like for someone in the audience to kind of post what is a freak-off.
So yeah, sure.
So
in chat over here, have them tell me what a freak-off is, because I don't know that term either.
I'm not familiar with it, but
I can guess, but I'm sure I don't know precisely.
But U.S. District Judge Arun Subramian disagreed with Combs' argument that under the Mann Act, prostitution requires a financial motive. The judge held Combs wasn't convicted of prostitution, but rather transporting others for prostitution. She stated Combs seemed to be conflating two things, the definition of prostitution and the motive of the defendant who transports someone for prostitution.
I do want to go back, and that's Mann, M-A-N-N, which happens to be coincidentally the same as a person that we're talking about here who happens to be a man, but it's the Mann Act, M-A-N-N Act. Thought that was kind of funny. But he was acquitted of most of the charges. Do I have that right?
Correct. Jurors acquitted Combs of the three top charges of his criminal indictment, 2 counts of sex trafficking and 1 under the racketeering, influenced, and corrupt organizations, or in other words, the RICO Act, but convicted him of the remaining 2 lesser counts of transporting individuals for prostitution.
What was Combs? Was Combs out pending trial?
No, Combs has been in custody for over a year. And it's amazing to me that the conservatives that are howling so loud about January 6th defendants being held, they don't realize that apparently this is common practice in the federal system. And also they forget that they created the practice themselves when they passed legislation that we can get into later. But they howl about something they created. Don't you think that's funny?
I think that would be irony. Isn't that irony?
Funny.
Wouldn't it be reasonable to think that this is a person of immense resources that you probably can't really trust him to go anywhere? He probably has his own plane and he's got contacts and he could get into another country without a lot of headaches.
I don't know that I would go that far because that popularity and being well known makes him easier to spot in other nations. So it makes it
very true,
very difficult to disappear.
Well, but you mentioned that the conservatives created this practice, but why is that? They forget that they created it. Why is that?
Well, they forget that they were the chief proponents of the Bail Reform Act signed in 1984 by President Reagan. And it was touted by conservatives that was going to keep these criminals off the streets. Well, they couldn't, while they were pending trial, they couldn't go out and commit new crimes. And so therefore, it's very likely that a person with a federal charge is going to be in some type of detention. Very rarely are they just told to go away and come back to court. They're at least strapped on with a monitor. But oftentimes they're in halfway houses, and sometimes they're in hard detention like he was. He was in a downtown lockup in New York, and I can guarantee that was no fun.
Probably not. But I bet you he had an amazing store call.
Well, they generally limit how much you can spend, so it's not.
They do, but I bet you he was maxing that thing out every week. He was facing up to 20 years in prison for convictions under the Mann, M-A-N-N, Mann Act, and he asked for a sentence of time served. Now, what is the Mann Act, though?
Well, it's a federal statute, United States Code 2421, passed by Congress and signed by President William Howard Taft in 1910. I actually worked in the Taft administration, but I don't recall all the details of the Taft.
What kind of position at that point? This was after you were for the Secretary of War, or whatever the hell it was at the time. What were you doing in 1910?
I worked in the Interior Department in the Taft administration.
All right. Well, because I am an AI guru, I did my own research on this. The law originally criminalized the transportation of women or girls in interstate or foreign commerce. And that means between two U.S. states or territories, or between a foreign country and the United States, for the purpose of prostitution or debauchery, or for any other immoral purpose. If we were to look at what immoral purpose in 1910 was, it would almost be like showing an ankle, Larry.
True. That's what we were trying to do.
The official title of the law, drafted by Republican Representative James Robert Mann of Illinois, was the White Slave Traffic Act. The act was significantly amended in 1978 to expand its application to boys as well as girls, and to specifically prohibit the interstate or foreign commerce transportation of minors, with the intent that such minors engage in prostitution or any other prohibited sexual conduct, which was pretty much anything other than missionary. Now, another major amendment in 1986 made the entire law gender neutral and replaced references to debauchery and immoral purposes or practices with the phrase any sexual activity for which any person can be charged with a criminal offense. 1986? It took that long to kind of normalize this? Good grief.
It took 76 years. So you did all that. So you don't need me here.
I definitely don't. You're fired. Now probably. We will tolerate you for the time being. The prosecution pushed for at least 11 years behind bars. They argued that the sexual performance that occurred during quote-unquote freak-offs and hotel nights are materially indistinguishable from, and indeed can be considered a form of, adult pornography. Now, what did Combs say in response to all that?
Well, Combs argued that this type of content is now ubiquitous on both unpaid, like, for example, Pornhub, and paid channels like OnlyFans, which I don't use both of those channels, but I do use one of them. But the judge... TMI,
Larry. TMI.
Judge Subramian, a Joe Biden appointee, disagreed. The judge said at some point illegal activity can't be laundered into constitutionally protected activity just by the desire to watch it. Combs' conduct goes far beyond that point, he wrote. Subramian said the government's evidence of Mann Act violations was overwhelming, pointing to trial testimony, text messages, and emails. The government proved its case many times over, the judge wrote. A new trial is not warranted, so it was denied.
Now, during oral arguments on the motion, defense attorney Alexandra Shapiro said Combs had a First Amendment right to produce the content. He was also a consumer of the amateur porn performances, she said, even at times the encounters weren't filmed. Well, that's nice. This is protected whether it's a live performance or not. Now, what did the government say to that?
Well, Assistant U.S. Attorney Mary Slavic argued that the Mann Act has no bearing on First Amendment rights and said Grammy-winning producer's notorious sex parties came down to a desire to meet his own sexual needs. Ms. Slavic said these freak-offs, they were about one thing only, the defendant's sexual gratification. He planned them, he choreographed them all for one purpose, which was to suit his sexual pleasures. But the problem is, Ms. Slavic, he has the right to do that.
In the government's 189-page sentence memo to Judge Arun Subramanian, the attorney Jay Clayton wrote that Combs, who is 55, is unrepentant and should be punished after he engaged in violence and put others in fear. Now, what violence occurred?
Well, I would ask our audience they should pose this question to the Trump Department of Justice, because we've been told that we're not going to have kabuki and unmerited prosecutions that are overreaching. It seems to me that the sex parties were consensual, but Cassie Ventura, Combs' former girlfriend, who gave lengthy testimony at trial about their relationship and the multi-day-long fueled sex sessions known as freak-offs, said in a letter that the events were degrading and disgusting. But that doesn't sound like violence to me, does it to you?
Not exactly. But let's be fair, this isn't Newsmax. And she said they left her with infections, illnesses, and days of physical and emotional exhaustion before he demanded it all again.
True, but still not violent. I mean, you have a choice. Now, lawyers for Combs said in their own written pre-sentence submission to, how do you pronounce that?
Subramanian. It sounds like submarine, but it's a little bit different. Subramanian. Whatever. Subramanian. Subramanian.
Subramanian said that he should serve no more. Now, this is in the pre-sentence submission from his attorney, said he should serve no more than 14 months, which could see him walk away in a matter of weeks because he's already served 13 months. Mr. Combs' celebrity status in the realms of music, fashion, and spirits and media and finance has been shattered, and Mr. Combs' legacy has been destroyed, his legal team wrote, and all that stuff is true.
And the government countered by saying that there's nothing mutual about a relationship where one person holds all of the power and the other ends up bloodied and bruised. Holy crap, Larry, he's worth $400 million.
Okay, but again, who ended up bloodied and bruised? I mean, maybe we don't have enough details, but who was bloodied and bruised by these freak-offs? That's why I want to know what a freak-off is.
Well, it sounds like she is saying that she had all of those issues with her at the end of the freak-off.
But this reminds me of Harvey Weinstein trial and sentencing. They allowed some testimony that was very questionable, and it seems like they've done the same thing here. A former assistant to Combs between 2009 and 2017 testified during the trial under the pseudonym Mia, wrote in her own submission to the court that the former music mogul should receive a sentence that reflects the years of coercion, financial abuse, humiliation, and physical and sexual violence, and the profound trauma that he's afflicted as a result. Again, I'm not aware of the violence, but maybe it was there.
Well, let's move on to the sentencing, which occurred yesterday. Combs was sentenced to 50 months for interstate commerce related to prostitution.
Well, but keep in mind that he was also acquitted of racketeering and sex trafficking charges earlier this year in July. And But the judge did hold that this falls under the Mann Act. Combs was convicted of 2 counts of violating the Mann Act. Each carries a maximum of up to 10 years.
Combs was sentenced to 4 years, 2 months, less than half of what the prosecution team wanted. The judge said during the sentencing that a lengthy sentence was needed as a deterrence.
And I think that this is long enough for that. And also a $500,000 fine and 5 years of supervised release were ordered. And even though he's not, I don't think, going to have to register as a PFR, not sure, but even if he doesn't, they will treat him, they will supervise him as if he is a PFR because they have that prerogative. So his supervised release will not be a piece of cake.
And what are your thoughts on how the trial proceeded?
Well, I found it a little bit disturbing. I object to Combs' pretrial release being denied on 3 separate occasions where motions were made. This meant that Combs stayed in custody until his actual trial, and being in custody makes it very difficult to prepare for trial. But it was supposedly due to the fact that the judge feared Combs would not return for his actual trial, which is what you said.
Yep. I also heard, and I just in passing reading a headline, so bear with me, but that he pled with the judge for mercy and leniency.
Well, I'm sure he did, wouldn't you?
I was very humble and just stood there and took my licks. So no, I did not. Do you think that helps? Does that sway? Does the judge then scratch off that he was going to get 120 months and then changes it to 50?
To the judge's credit, I think that it did, or something did, because that the exposure was 20 years at least on those 2 Mann Act violations. The government was asking for slightly more than half of that, and he received less than half of what the prosecution wanted. So that still means that there was something that swayed the court not to impose to be as harsh. So this is not nearly as bad as it could have been.
Very well. Anything else you want to talk about this before we move on?
Well, I just tell the audience it may be like me that has no idea who the heck is this guy and why is he famous?
Because he makes music, and then that turned into fashion, and then that turned into perfumes and so forth, and colognes and all that stuff. And $400 million, man, that's a lot of dough. You got that much, right?
Not in the grand scheme of things. I can think of people that have numbers that go into multiple that starts with a B, not M.
Well, of course. But even like Paul McCartney is only, quote unquote, only like worth $1 billion.
Is that all?
And we all knew. Only, and I say that with a lot of quotes, but I'm just thinking for all that the Beatles were, and then him and his solo career, and all that, and quote unquote, all he's got is $1 billion.
I don't know
but
how
he invested into several other things.
I don't know how he would survive on such a paltry amount of money.
It would be really, really tough. There's another artist. She did the Super Bowl a handful of years. Rihanna. She is worth a truckload of money too, for similar reasons. She is worth $1.4 billion, and I know you don't know who that is, but she did the Super Bowl a handful of years ago, and pregnant, and everyone went bonkers because anyway. But yeah, she took her music and then took that money and invested in businesses and so forth. And I didn't realize that she was worth $1.4 billion. That's a lot of dough.
Well, you can provide my number if you like.
Yeah, I will totally do that. All right. So I was reading some messages that I found, and I wanted to bring this up to you. And I've kind of like generalized it, no names or anything that has all been changed to protect them. But it's one of those questions that seems super simple on the surface, but once you dig into it, there's a lot going on underneath. And the question was, and if you're on the registry, and especially if you're still under supervision, can you legally attend a public workshop that happens to be held at a church? And this isn't about religion at all. It happens to be when civic or legislative meetings use church facilities. There happen to be kids or daycare facilities on site. People are genuinely worried that showing up might land them in trouble.
I love the question. It's one that crosses the lines between registry rules, supervision conditions, and even First Amendment rights. So let's unpack it. Let's see how well you did setting this up step by step.
All right. Well, so picture this. There's an advocacy workshop in open to the public, and it's about learning how to contact lawmakers, talk about policy, and advocate for better laws. Now, the problem is it's being hosted inside a church that rents out community space, and there's a daycare in another part of the building. Someone on the registry wants to attend but thinks it might violate their conditions. They're being told two different things. One person says, you can go. The registry doesn't forbid it. Yet another one says, you can't because your probation officer will see it as you being near children. So who do you think is right?
Well, they're both right in some aspect of it, and that's where the confusion comes from. I agree with both. You have two separate sets of rules. You've got registry law, and you've got supervised probation or supervised release conditions, and they sometimes are extremely different.
Well, let's begin with the registry side of things. Does it actually say, now this takes place in Georgia, so I realize that that's kind of specific to it. Does it actually say anywhere that you can't be near a church or that you can't go places where children are present?
In many states, and this is the case in Georgia, the registry doesn't have a blanket rule that says you can't be somewhere. What it does prohibit is loitering in areas where minors congregate, parks, playgrounds, daycares, and so forth and so on. Loitering means hanging around without purpose, not being there for a scheduled event or a legitimate activity. So if you're attending a workshop or class, to me that's not loitering. You're there for a clear, time-limited, and lawful reason.
And so if you're there just to go to an event, that shouldn't trigger any sort of registry challenges?
I would think not, correct? As far as the registry is concerned, and I continue to maintain my personal opinion, it's none of the government's business who's on church property, period, because we have a wall of separation. But that's a discussion for another day.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app, hit the subscribe button, and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
And then let's go over to the other half of the equation. If the person is on probation or parole, on some kind of supervision.
Now, there's exactly where the problem is. If you're still under supervision, your officer might have and likely did impose conditions that go well beyond what the registry prohibits and requires. For example, a probation officer might say you can't go within 1,000 feet of a daycare or playground. I've been told that they tell people in conditions of probation don't drive alone.
But that was one of the special conditions in Georgia.
So those are supposedly individualized conditions, not always, but supposedly to be constitutional. But they're not in the law itself. But they're attached to your sentence by the judge or the probation department. So even if the registry doesn't stop you, your supervision might.
And as I recall, Larry, the special conditions of probation, you shall never drive alone, especially where children are known to congregate. And I was like, that's extra no. How do you know? And that's NO. How do you know? How do you never do the thing and then especially never do it under these conditions? You already couldn't do it to begin with.
It seems like a double prohibition. You already can't do it, so you don't need the especially.
And then when your probation officer says, I need you to come up here to the office, should I tell them to refer to rule number whatever it was and say, it says I can't drive alone, and say, sorry, you come here?
I think that would be a good recommendation.
All right, well, with all that in place, and that means the smart move is to ask permission first before attending one of these workshops?
Well, I want to say absolutely, but I'm equivocating, but I would say yes, if you're under supervision. Probably, yeah, I would make that stipulation to always ask. And you want to be able to prove that you made the ask. like in writing on text or email or something that you can document later. That way, if anyone questions it, you can show approval in good faith. What I hear often from people under supervision, they claim that they don't get responses to these text messages, and they claim that nobody answers their phone anymore. I think you're familiar with that.
I
And
am.
they claim that they cannot get communication and approval from their PO. And I said, well, then you have to write it in the negative. You have to say, I'm planning on going to this church for a meeting about whatever, and unless I hear back from you, I'll assume it's okay.
I think that would be fair.
And
at least you've done that of making them aware of it. I mean, what are you supposed to do, Larry? Are you supposed to like get out the old typewriter and whoosh, 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 and put it in an envelope and then certify it and send it to probation so that you know that someone received it?
I don't know what you're supposed to do, but I hear people all the time say their POs ignore them.
And this is where things get interesting. Some people argue that stopping someone from attending an event like that, especially a legislative workshop, that would violate the First Amendment. What is your thoughts on that?
It's a very strong argument, and I think they're likely right. Think about it. The First Amendment protects your right to assemble, to speak freely, and to petition the government for redress of your grievances. This means you have a constitutional right to engage in civic activity, and even if you're on the registry. If the government, through probation conditions, block you from attending a meeting that's literally about petitioning the government, that's a real problem, and it's a potential constitutional violation.
And so what you're saying there, it's not just a technical argument, it's a fundamental piece of democracy?
Exactly. You can't fix bad laws if you're barred from participating in the process that fixes the bad laws.
Well, if you don't mind, if you'll, if you'll entertain me here, let me throw out a hypothetical. Now, let's say a man, and we'll call him Mr. H. He wants to attend a civic workshop held at a rented church hall. He's still on probation. He checks his paperwork and sees that a line that says he can't be within 1,000 feet of places where minors congregate. He asks his PO for permission to attend, and the officer says no, citing the daycare inside the church. Mr. H points out that it's a public civic event, not a religious service, and that the children aren't attending, but the officer still says no. Does Mr. H have a case?
Potentially, I would like to think so. This would be a textbook First Amendment issue in my book. If the only reason for denying him is the location and not his behavior risk, then the government is effectively silencing him based on geography. And that's not what the Constitution, I think, allows. Courts have long recognized that restrictions on speech and assembly have to be very narrowly tailored to serve a compelling government interest. Preventing someone from attending a lawful, adult-only civic event doesn't meet that test. Now, what the PO would say is that nothing prohibits people from bringing their children to the church for the same civic meeting. That's what they would say.
And assuming that the PFR is there, that he's going to spontaneously see the child and going to violate them in front of everybody. It's going to be like a werewolf turning into a person turning into a werewolf on a full moon without any sort of control. And they're just going to violate everyone that's a minor in the room. That's what they're imagining.
Yeah, and the whole thing is absurd. It's kind of like not letting PFRs vote in polling locations that are in schools.
Yes.
Now, most schools of any significant size have quite a large number of staff, and they have resource officers, cops, all sorts of things. And to think that somebody's going to come into a school on election day where there's the poll workers, the regular school staff, the security and all this, and do anything, it's the most ridiculous thing I've ever heard.
And clearly everyone is off of work. They're off school those days typically.
Correct.
But in the real world, most people aren't trying to go to court, and they just don't want to. They don't want to get violated either.
And that makes sense, and that's where risk management comes in. You might be legally right, but still face a violation or arrest before it's sorted out. So here's the practical advice: always try to get permission. Keep a copy of copy with you if you attend of that permission. Stay in the part of the building where the event is held. Don't go out meandering and loitering around, and avoid wandering into any areas that might be intended for children, even if they're not occupied. These steps don't just keep you safe, they also demonstrate intent, which matters if anything ever comes up in court.
And if I may be so brave, if you do the text message thing and you don't hear anything back and you get jammed up, they're going to potentially take custody of your phone. Now you don't have your evidence. So keep a copy of it with you. You should probably do something to have it in a physical copy, even if it's just a screenshot of the text messages.
That's right, and store it on the cloud where somebody else can get access to it while you're in pretrial detention on your violation.
Very, very smart move. I would also then say, Larry, that you should probably try to never be alone at least where there's always people around that can keep eyes on you, even if they know nothing about you, but that you've never well, I went around this corner and no one could see me for 5 minutes. Who knows what happened during those 5 minutes? Does that make sense?
It does indeed.
All right. Well, then there's another side to this too for people organizing these events.
Absolutely. Advocacy organizations need to be mindful if they're in this area of advocacy about where they hold meetings. Choosing neutral or public spaces like libraries or community centers avoid putting registrants in impossible situations. But even a library doesn't abide it, necessarily negate it. We had to sue here in Albuquerque because they made the libraries off limits. But we can't push for reform while unintentionally excluding the very people that are most affected by the laws we're trying to reform.
And that is exactly right. Accessibility starts with location. And let's wrap this up before we take this too long. Here's what we've covered. The registry law itself doesn't ban being at a church or a place where kids might be. Loitering is about behavior, not presence. Attending a legitimate event is not loitering. Supervision conditions can add stricter limits, so always check first. And the First Amendment gives you a strong constitutional basis for participating in civic and legislative events.
Exactly. And the broader lesson here is that even when the law technically allows something, you have to navigate carefully because of how it's likely or could be enforced. Know your rights, but also protect yourself with documentation and common sense, which some people don't like that word. If enough people challenge these overreaches the right way, calmly and lawfully, eventually the courts will draw clearer boundaries about what is allowed.
All right. The one other thing that I would, it sounds like almost like something you would do, Larry, is wouldn't you just flip then the bird? You would go do the event and you would take your licks and go see the judge at some point in time and go, I have that right, and let the judge challenge what probation is up to?
I might, but I might not, depending on circumstances. In this state, being that the probation can issue a detain and hold without having to ever see a judge, and they've got a number of days, 3 or 5, I've lost track, to actually perfect that to a judicial hold. You can lose your job and everything while you're waiting for the judge to read their purported violation and say, no, this is not enough to hold the person. They've already been held and screwed. So I wouldn't flip the bird depending on the circumstances.
Well, very good. I believe that we have time to do a little bit of some extra stuff about IML. Are you prepared for that?
I hope so. I would love to do this because I've been getting all kind of obscene phone calls and emails and people telling me I don't have a clue what I'm talking about. And if Obama had just vetoed it, we wouldn't be in this mess.
Well, as you just said, so over the years, people just flame. Well, why did that communist sign IML into law? He has the power to veto it, right? We were kind of joking about that at the beginning. What does that even, what does that process look like? Does he have a stamp that says, ka-dunk, veto? But so why didn't Obama veto this back in the day if it's such a garbage law?
Well, first, there was a number of reasons. First, it was passed by Congress nearly unanimously. And that in and of itself makes a veto very unlikely. Second, based on the margin it passed by, which was nearly unanimous, he would not have been told that there were any problems with the legislation. When something is passed unanimously, that signifies that the American people are in agreement with this. They have expressed that agreement with their elected representatives and senators. And the president would not instruct his staff to say, well, something passes 434-1, to say, well, I'm a little skeptical about this. Y'all go do some digging. He wouldn't have been told that there was anything wrong with it. And third, he was showing, you need to ask a question.
No. I was just breathing. Sorry. I thought it was my time.
Third, he was showing he could be bipartisan and sign a Republican proposal into law. And finally, he possibly and probably supported it himself because the concept makes some sense that you wouldn't want people who have a proclivity to commit acts, horrible acts against children, to be freely navigating the world. So there's a whole bunch of reasons why he didn't veto it, and we'll get into more of it later. But go ahead.
I'm intrigued by the third one that you just covered there. He was showing he could be bipartisan and sign something that a Republican had introduced.
Yes, he got criticized. Republicans were running the show back then, and we'll get into the numbers later, but the Republicans were running the Congress back then. And he was so vehemently criticized because he didn't have any bipartisan bone in his body. And something came to him bipartisan, and he signed it.
Now, I remember way back in the day when IML had crossed the finish line and it was headed to the president's desk, you urged that the pressure should have been applied to Representative Smith. And that's the goofball from New Jersey that introduced this thing. And I also remember an attorney from California dismissing that idea, and that the attorney recommended waiting for legislation to go to a conference committee. The attorney said it would be fixed in conference and that wasting time with Representative Smith was unwise. That sounds really politically wonky and behind the scenes smoke and mirrors stuff. Can you dig into that and explain that?
Well, yes, I can. The attorney didn't and probably still doesn't know shinola about the legislative process.
What is shinola? I've never heard this word.
Well, you can have our vast studio audience Google that. I think there's an expression that has something, but the two words, they don't know SH or shinola.
I totally understood what you were saying, but someone asked, is it like a shiitake mushroom?
So the attorney doesn't and didn't and probably still doesn't know shinola about the legislative process. The attorney did not realize that legislation does not go to conference committee unless the version passed on one side of the rotunda is different from the legislation that passed on the other side of the rotunda in the other chamber.
Can you please explain that in more detail?
Okay, sure. Except for Nebraska, all states and U.S. Congress are bicameral. Nebraska is the only unicameral, so you only have to do this kabuki exercise once in Nebraska. This means that each chamber must pass an identical bill. In this case, there were amendments made in the Senate to Representative Smith's House bill. It was H.R. 5, whatever that number was, and it was amended in the Senate. And that means in order for the bill to be passed and sent to the president's desk, those conflicts must be resolved. And there are a few ways to resolve those conflicts. And a conference committee comes into play when there are unresolved differences that could not be hashed out by the steps that are available but prior to a conference committee. And this brilliant attorney did not seem to understand that. There was no conference committee needed in this case.
Well, what are some steps that might be easier instead of?
Well, glad you asked that because I'm sure people are confused. So let's help illuminate the importance of This will help illuminate the importance of Representative Smith. The first question that would have happened when the Senate amended Representative Smith's bill on their side of the rotunda, that would have been, Representative Smith, your bill has been amended in the Senate. Do you consider the amendment or amendments to be friendly? And old, long-standing tradition of legislative process is that the sponsor, the lead sponsor, is given a wide amount of deference because they're the one that worked it. And he worked this, as you remember the last show, since 2007. He's been trying to pass this. And if the sponsor says, yes, this is a friendly group of amendments, the full House membership would have taken his recommendation and voted to accept the Senate amendments. And that's called concurrence. And that's what happened. So the first thing that happened was it was reported back to the House that the Senate had amended the bill and asked, would the House like to concur? And the House took a voice vote and said, yes, we concur. But if they had said no, then a message would have sent back to the other side of the rotunda, and they would say, the Senate, to the House rejected, to the Senate, the communication would have been, House rejects, Senate proposed amendment, whatever that amendment number was. Will you recede on this amendment? And if the Senate said, hell no, we won't recede, that amendment stays or this bill dies, then that's where you get a conference committee in that scenario. That's one of the things that triggers a conference committee.
And is that what happened in this case?
It is indeed what happened in this case. If you refer to a document in Dropbox that I have highlighted where Representative Smith's recommendation was made, and I think it's if you open that document, if you can take the time to show it to the audience, you can see what I'm talking about. And I'll try to go through it with you. I'm trying to go through it with you, but I'm having trouble getting this thing to open. But anyway, about the seventh entry down on that document, it explains that Representative Smith said, accept these amendments. Well, that ended any further debate because it was December of 2016. People wanted to go home. It was late in the year. I don't know if it was December, but I think it was. But the people wanted to go home. And he said, I consider the amendment to be friendly. And that there was nothing else needed to be done because it was a friendly group of amendments.
I gotcha.
All right. Did it open for you? Because I'm having trouble opening it, and I'm the one that created it.
Yes, I see Congress.gov and HR 515. Do you want me to advance to a particular section?
Yeah, where I got the highlight showing that what Representative Smith said. Yeah.
Mr. Smith, NG, moved that the House suspends the rules and agrees to the Senate amendments. And that's consideration. Is that CR? Is that continuing resolution?
I'm not looking at it, so I don't know what it is. I can't get my own document to open.
Well, it's CR and then H387-394. I'm assuming it's a continuing resolution. Assuming. And then there's another highlight that you put and this is on 12/17/2015. Passed Senate with an amendment and an amendment to the title by unanimous consent. Now, this is the U.S. Senate, correct? So there's 100 people.
Yes, and when it passed the Senate, then it had to go back to the House to be viewed again because it wasn't identical. And if they had said, no, we reject the amendments, Conference Committee would have been appointed. But that's where the person didn't know Shinola, because when they accepted the amendments, there was nothing else left to do. It matched at that point. What would you confer about?
I understand. All right, so I put the document there for people to see, and it's on the screen for people to see. And let's see. Now, what would have been the circumstances where a conference committee would have been appointed then?
That occurs when the originating chamber considers the amendments unfriendly and they reject the amended version. And I tried in vain to explain this to the guru to no avail.
Now, would it have mattered if pressure had been applied to Representative Smith?
Probably not. He'd been trying to pass IML for over a decade. So if you had taken an entourage of people telling him that he was going to be going down in history as some horrible individual for accepting passport markings, it's very unlikely he would have rejected the amendments because, in his view, he would have thought it made the legislation stronger. And he would have said, holy crap, I never dreamed of having something so good as this.
And the amendments that you are referring to are the passport markings?
Yes, those amendments were made by Senator Mitch McConnell, your favorite senator from Kentucky.
Oh, he's the best ever.
And former Senator Corker from Tennessee. And neither of those, by the way, are members of the Democrat Party.
Now, why is that significant?
Because with the Democrat Party is getting blamed for not vetoing it.
Ah, I see. All right, well, and then which party controlled a Congress in 2016?
Well, it was definitely not the Democrat Party. The Republican Party had a numeric advantage of 54 to 44 seats in the Senate with 2 independents, and those independents typically caucused with the Democrats, meaning they voted with them. So that gave a 54 to 46. Well, you can't do much when you got only 46 seats. And the Republicans controlled the House by a 246 to 186 seat majority, and there were 3 vacant seats. Folks, elections have consequences. And you're mad, but you're mad about what you did to yourself.
I just want to ask you, because this is currently going on with the government shutdown, that they are trying to get to 60 votes to pass the budget, whatever. They didn't have to get 60 votes, so one party could have potentially stymied this with the split that way?
I'm not understanding your question about you're talking about the government shutdown, and there's a whole complicated stuff of budgeting I'm not intelligent enough to talk about, where they have that 60 seat threshold except for budget reconciliation, and I can't really explain that. But in general,
go ahead. I was just saying, because at some point in time, I thought everything had to pass the Senate with that 60 or something threshold, but somewhere along the way, and I think the Democrats started it, that they started removing those thresholds to make it a 50-50 split, 50+1.
yes, it's been eroded, and I can't give the sequence of how it's been eroded, but the Democrats started playing politics with judicial appointments back during George Bush's administration. Big time. I mean, there's always been politics in that process, but they started holding up appointees like Miguel Estrada, for example, for the Court of Appeals. And then when the Obama won, payback was on the horizon. So they held up all of his appointments. And then Senator Reid, who was the majority, said, hey, we got to govern. And so they changed the rules. But they left the 60 vote threshold for the Supreme Court. Well, Mitch McConnell, to his credit, he told Reid, you will regret the day you did this.
Yeah.
He said, don't go down this path because you're going to regret it. And sure enough, when it came time that they needed to steal the Supreme Court seats, they've reminded the Democrat Party of what the Democrat Party did, to start us down this slippery slope. So I don't hold the Democrat Party completely blameless in this. But I will say this about the Democrat Party. They have never stolen a Supreme Court seat. The Republicans were the first to steal Obama's legitimate seat that he should have made in February of 2016 when the Chief Justice passed away. Not the Chief Justice, excuse me, the Associate Justice. What's his name? Scalia. It was not the Chief Justice. But when the Associate Justice passed away.
Now I heard someone say, well, it is the president nominates with the advice and consent of the Senate. So they would still, like, the process was followed. This is what someone argues to me, a mutual friend of ours.
Yes, and I know who you're talking about in all likelihood, and that someone doesn't know Shinola about what someone's talking about.
Boy, I hope the transcription comes up with what Shinola is.
So, because the process through the history would be that the person would be considered. Turtleneck McConnell made a proclamation within hours after the death of Scalia got out that he would not even consider an appointment. That is not advice and consent because he refused to consider it. And let me just set it into context. We had a president in 1974 that assumed office on August 9th, that was never elected to the vice presidency, much less the presidency. Do you happen to remember that president's name?
That would have been Ford, if I'm not mistaken.
Yes, Mr. Ford was sworn in on August 9th, 1974. And his term was to complete the second term of his remaining term of President Nixon, who would have been in office through 76 and would have left in early 77. So Ford was effectively a little over a year presidency. A little bit longer than what Turtleneck decided was the rule he invented. But President Ford was allowed by a Democratic Senate to appoint a person to the Supreme Court to replace the most liberal justice we ever had at that time, named William O. Douglas. And there was all this fear that Ford would put an ideologue up, and the Democrats' leadership told him, put a moderate up, Mr. President, we'll confirm him. They considered and they confirmed John Paul Stevens, who turned out to be a fabulous justice. He was not as liberal as O. Douglas, but he was a great justice. So the Democrat Party could have stolen that seat had they wanted to in 1975. They didn't. And not only could the Democrat Party have stolen that, the Democrat Party could have stolen the presidency. When Vice President Agnew was forced to step down for corruption, President Nixon was allowed to make an appointment to fill the vacant vice presidency. And under that process, it had to be approved by both the House and the Senate. And Gerald Ford, congressman from Grand Rapids, Michigan, was almost unanimously approved by a Democratic Congress. And if they had just stalled and said, we ain't going to consider it. That happened in 73, in late 73, in October of 73. They could have dragged that out. Nixon resigned the following August in 74, and Speaker Carl Albert from Oklahoma would have become acting president. The Democrat Party could have stolen the presidency, but they didn't do that either. So get off your high horse saying that the Democrats do the same thing. They had not done the same thing until the Supreme Court seat was stolen in 2016.
Very well. I understand. I agree very much. It seems a little sketchy. But that, and then on the other side of that, they pushed Amy Coney Barrett through in a week or like a month or something like that.
In October of the final of Trump's term, magically, Turtleneck's proclamation that the American people should get that. Magically, he did a flip-flop and he forgot all about what he had said. And of course, the person you're talking to will say, but that was because Obama was in his second term. That's what he'll say. So I already know that. I don't need to hear it. That's what he will say. So, but magically, the American people didn't get to decide who got that seat. He did a flip-flop within just a few months' time. Isn't that amazing?
I'm with you. I watched it all happen.
And what's so amazing is all these people never call out their team. I just got through ranting against the Democratic Party for several minutes here about things that they did that caused part of this. I won't get a peep out of a single conservative Republican. They will never criticize their team, and I find that so frustrating.
I understand. Wow. You get kind of riled up, Larry.
Because they're not intellectually honest.
You've been listening
and it
to
really bugs me because I try to be
P.
fair and right down the middle, and I try my best to call a spade, and I get nothing but excuses from them about everything. They see no evil when it's their team.
I understand. Well, very well. I think we are done. Are we done?
I think so.
Head over to registrymatters.co to find show notes, links to how to join the Discord server. See, that's in reference to someone that needed extra instructions. You can find it on pretty much every episode that has ever existed since we've had a Discord server. Email over at registrymatterscast@gmail.com. Leave an old-fashioned voicemail message at 747-227-4477. Larry, funny thing today, I was sitting there at the bookstore, and somebody starts messaging on the phone number, 747-227-4477, and like, hey, what you doing? I was like, nothing. And so is this Nikki? Nope, not Nikki. Is it another name? Was it Nicole? Like, no, that's not. Well, who is this? I said, Andy. Oh, sorry, dude. I was like, hey, man, good luck. Just random text messages start showing up. Anyway, and then you can support us over at Patreon, patreon.com/Registry Matters for as little as $1 a month, and that will gain you access to the Discord server and other wonderful benefits. And also head over to fypeducation.org/shop to get your kabuki shirt and whatever else you find over there that you would like. And that's all I got, sir. You're going to have a fabulous weekend. You got football picks. Do you still do the lottery with your friends?
Yes, I'm ahead again this season. There's 4 contestants, and I've won 2 weeks, and one contestant hasn't won anything, and the others have won 1 week each. So I just don't understand how I can know nothing and still beat them.
You don't put emotion into it, and they have some kind of skin in the game of who they're trying to like. That's what it is.
I think so.
Well, very good. Thank you, everybody, for hanging out. And Larry, I hope you have a fantastic weekend.
Good night.
You've been listening to FYP.